Everyone. I am pleased to introduce Paul Copeland, who is a very well-known Toronto human rights lawyer. He co-founded the Law Union of Ontario in 1974, was the vice president of the Criminal Lawyers Association from 1985 to 91, and for several years was the co-president of the Association in Defense of the Wrongly Convicted. He is a life bencher with the Law Society of Upper Canada, and since 1988 he has been active working with the democracy movement in Burma. Mr. Copeland is the Burma Monitor for Lawyers' Rights Watch Canada and has been an LRWC member and director since 2001. He is a recipient of the Sidney B. Linden Award from Legal Aid Ontario, the G. Arthur Martin Award from the Criminal Lawyers Association of Ontario, and the Law Union of Ontario Award. He is a partner at Copeland Duncan Barristers and Solicitors in Toronto, primarily practicing criminal law, immigration law, and civil litigation. Mr. Copeland's practice has a special emphasis on national security cases. His among his notable cases in that area was his 2006 submissions to the Supreme Court of Canada on behalf of Mohammed Harkat, where he argued that the security certificate procedure under the Immigration and Refugee Protection Act violated the fundamental justice provisions of Section 7 of the Canadian Charter of Rights and Freedoms. In February 2007, the Supreme Court of Canada unanimously agreed with his argument and held that the procedure violated fundamental justice. Mr. Copeland holds an LLB from Osgoode Hall Law School of York University and a Bachelor of Science from the University of Waterloo. He has participated in various educational programs in criminal law, immigration law, ethics, freedom of information, and national security held by the CBA, the Criminal Lawyers Association, the Law Union of Ontario, and the Institute of Continuing Legal Education of the CBA. He has lectured and participated in various seminars at law schools across Ontario. On behalf of Lawyers' Rights Watch Canada, I thank Mr. Copeland for attending today to speak to us about the very interesting and important topic, criminal violations, civil liability, professional misconduct, and unethical practices, lawyers in national security work.
Thank you very much, Kara. I've got a lot of speaking notes here, and I'm going to be referring to them because there's a lot of detail in them. There's been a lot written on national security and on lawyers' involvement in the abuse of law and the abuse of detainees. Many of the materials have been written by academics or people who are partly academics and partly practicing lawyers. I'm a practicing lawyer, and my involvement in this came as a result of my work in the Mohammed Harkat case. Part of my interest in it comes as a result of my being a director of the Law Society. I suppose most everybody in the room will know, but if anybody's watching this on video eventually, the benchers of the Law Society deal with discipline of the 41,000 lawyers in Ontario, so I've sat on discipline tribunals over the years. The spring of 2004 was retained by Mohammed Harkat. He'd been represented by a couple of other lawyers. He'd been arrested on Human Rights Day, December 10th, 2002. I did work for him throughout that case. When we were eventually successful in getting him released on bail, I got retained to help on the bail applications of two of the other security certificate detainees. With a guy named Matt Weber, who was my co-counsel on Harkat, we argued in the Supreme Court of Canada the unconstitutionality of the security certificate provisions, and we were successful in that. Eventually, after the changes in legislation, I'll talk about it a little bit later, I was appointed as a special advocate in two of the, security certificate cases, the Harkat case and the Omri case. The Omri case is now finished. And he was actually, the certificate was found to be unreasonable in his case in December of last year, after 7 years in jail, mostly in solitary, and a year in very restrictive bail. Mr. Omri is released and he's free wandering around mainly Mississauga, which is where he lives. Let me go back to the summer of 2004 because that's when I get started in this. And we got the open source material in Harkat. One of the pieces in there was the following paragraph. It says the service, which is CSIS, believes Harkat was associated with Abu Zubaydah, one of Osama bin Laden's top lieutenants since the early 1990s. Abu Zubaydah was recently captured in Pakistan and has been reported to be cooperative with the United States authorities. Well, I looked at that and I thought, reported to be cooperative. I wonder what the hell that means. So I thought about it for a little while, and I sent a letter to the government counsel, a guy named Jim Matheson, and in this case, we copied everything to the court. So what I said to Mr. Matheson was, when I read the term reported to be cooperative, I thought that meant that Abu Zubaydah was being tortured by U.S. personnel or persons assisting the U.S. government in extracting information from Abu Zubaydah. I sent along some media reports that suggested some of the debates that were going on. I also provided Mr. Matheson shortly after that with a copy of what's known as the Gonzalez Memorandum. It's dated August 1st, 2002. It was really written for how to deal with Abu Zubaydah. It had only recently been released. I got it through the Arar Commission inquiry. It was written by a guy named Jonathan Yu and signed by a guy named Jay Bybee. They were both lawyers in the Office of the Legal Counsel of the U.S. Department of Justice. I want to read to you one little portion of that. Page 13, the definition of torture was as follows. Each component of the definition emphasizes that torture is not the mere infliction of pain or suffering on another, but is instead a step well removed. The victim must experience intense pain or suffering of the kind that is equivalent to the pain that would be associated with serious physical injury, so severe that death, organ failure, or permanent damage resulting in the loss of a significant bodily function will likely result. Then I got something from Mr. Matheson, which basically said what they'd gotten, the Americans had gotten from Abu Zubaydah, was that Mr. Harkat operated a guest house in Peshawar in the mid-1990s for Mujahideen traveling to Chechnya. Mr. Matheson sent me a letter in which he said, you appear to be making certain assumptions in your correspondence with respect to Mr. Zubaydah. Your assumptions do not appear to be supported by reliable evidence. I would not necessarily categorize a media report from the internet or European or North American media as constituting reliable evidence of torture. So I wrote back to him and I said, what disturbs me the most about what you said is that you say my assumptions about the torture of Abu Zubaydah do not appear to be supported by reliable evidence. Does this service, and do you take the position that the Americans and their proxies did not and do not torture prisoners? Did you read the memo for Alberto Gonzalez? The last thing I said to him was, are you prepared to go to the United States and take commission evidence as to whether Abu Zubaydah was tortured? We eventually got to argue these issues before Justice Dawson, and we filed a Human Rights Watch report, a briefing paper entitled The United States Disappeared, the CIA's long-term ghost detainees. Abu Zubaydah was one of those detainees. I also filed a declaration from a lawyer named Stephen Watt in New York, who worked at the Center for Constitutional Rights, and Center's done most of the significant work for detainees in Guantanamo and for many of the people who were captured. They worked for Mayor Arar. But what Stephen said in his affidavit is it's clear that detainees in U.S. custody control in Afghanistan, Guantanamo, and other undisclosed locations, including Abu Zubaydah, who at that point was in a black site somewhere, have been subject to a regime of treatment, including interrogations which constitute cruel, inhuman, or degrading treatment, and in many instances, torture. We also filed with the court Ward Elcock's complete transcript of Lorne Waldman's cross-examination of him at the Arar inquiry, and Lorne was saying the Syrian military intelligence engaged in torture. And if you read the transcript, you'll see the twists and turns that Mr. Elcock took. But basically what he said is I could never conclude that. And I'm not going to read you from this bits of the transcript. But Syria is notorious for torturing prisoners, and has become more notorious with the Arar inquiry and with the Yakabuchi inquiry.